Hey guys, as we all know, one of the main features of the constitution of our country is the separation of powers and the independence of our judiciary. In fact, that's one of the main reasons why the judiciary is held in such high regard. But sometimes certain events take place that make us question whether this line that exists between the executive and the judiciary is blurring day by day. And the event that has sparked a controversy this time around is the nomination of former Chief Justice of India, Justice Ranjan Gogoi, to the Rajya Sabha 4 months after his retirement from office. Now, the reason this is a problematic move is because Chief Justice Ranjan Gogoi formed part of and headed multiple benches that had the government as a party, and in more occasions than one ruled in favor of the government. Some of these judgments included the Rafale verdict as well as the Ayodhya verdict. Fairly recently, we saw another such controversy wherein a senior judge of the Supreme Court, Justice Arun Mishra, while he was delivering a speech at the International Judicial Conference, heaped praises over the Prime Minister Narendra Modi, calling him a versatile genius and using phrases for him such as think globally and act locally. This act was condemned by various lawyers and legal luminaries of the country, as well as former retired justices of the Supreme Court such as Justice P.B. Sawant and Justice A.P. Shah. A similar instance was seen when Chief Justice of the Patna High Court back in August 2019, Justice M.R. Shah, used terms like a model and a hero for the Prime Minister. However, for those of us who think that these acts and these instances have only begun post-2014 are mistaken. Historically, there have been cases where people have condemned the coming together of the judiciary and executive and leading the common public to believe that there is a collusion between the two. Here we look at some of these events. Back in the 60s and the 70s, it was a very tumultuous time. We had the executive and the judiciary that was at this constant tussle, wherein one would bring in an amendment and the other would bring in a judgment to negate the effect of this amendment. During this time, we had the Golaknath decision, wherein the bench headed by Chief Justice Subbarao ruled against the government. Soon after, Chief Justice Subbarao would go on to become the united opposition candidate in the next presidential elections and fight against the government. The problem is, even though his nomination papers were filed after he retired from office, it is said that the talks for the same were held while he was in office. Now, Justice H.R. Khanna and Justice V.R. Krishna Iyer also stood for the presidential elections back in 82 and 87 respectively. However, they did so a while after they retired from office. Next up, we have the former Prime Minister Indira Gandhi and the 1980 general elections. Justice Bhagwati wrote this open letter wherein he complimented the Prime Minister on her remarkable achievement of winning this election. This was condemned by the legal community, stating that it was not right on part of judges to compliment the executive or pat their backs, as it showed that there was a collusion and then there was intrusion between the executive and the judiciary, and Bonhomie more so. It is interesting to note that Justice Bhagwati was one of the judges who ruled in favor of the government in ADM Jabalpur vs Shiv Khan Shukla, also known as the habeas corpus case, which also is known as the biggest black dot in Indian democracy and Indian judiciary. 30 years after that judgment, Justice Bhagwati admitted to have erred in it and wished that he could go back in time and change his decision so as to form the dissent along with Justice H.R. Khanna. He said that it was not right on the part of the government to suspend the fundamental right of the citizens during the imposition of an emergency, and as has been held by the Indian judiciary in subsequent decisions, that decision was not sound. Another situation we see these days is former justices of the Supreme Court being appointed as governors of various states. One such judge was Justice Syed Fazal Ali, who was appointed as the governor of Orissa, and fairly recently, Justice P. Sathasivam was appointed as the governor of Kerala. Now, it is nobody's case that such a proposition is not sound or that a former justice cannot be a governor of a state, but there should be a cooling off period between when a judge retires from office and when he is appointed in a different office post-retirement, because it gives rise to an impression wherein whenever there is a person retiring from office and immediately assuming another office, that his pre-retirement decisions or judgments were in favor of the government in seeking of a post-retirement job or service. The last of such instances, and probably the one that stands out the most and is the most peculiar, is that of Justice Baharul Islam. Justice Baharul Islam's case stands out because his trajectory was different to other judges. He did not start off as a judge, he started off as a politician from Congress who was a two-time Rajya Sabha member, only to resign in 1972 and later be appointed as a judge of the Assam and Nagaland High Court. He then later on became the Chief Justice of the Guwahati High Court before retiring in 1980. In what was an unprecedented move by the Supreme Court at the time, Justice Baharul Islam was out of his retirement appointed to the Supreme Court, and he served for 3 years before resigning from the Supreme Court and standing in the Rajya Sabha elections from a Congress ticket and becoming a Rajya Sabha member for the third time. Now, the controversy in this case is that there were allegations of a quid pro quo agreement, because in one of his judgments right before he resigned, he had exonerated a Bihar chief minister in a corruption case, the chief minister being Jagannath Mishra. The fact that the BJP points it out to this day shows just how much the image of the judiciary is tarnished whenever there is collusion between the executive and the judiciary. Jagannath Mishra, who belonged from the Congress and was the Bihar CM, was exonerated, and then from a Congress ticket, Justice Baharul Islam became a Rajya Sabha member for the third time, so it obviously raised a presumption that there was collusion between the two. Coming back to the nomination of former Chief Justice Ranjan Gogoi to the Rajya Sabha. Now, it is true that the constitution does not bar such a practice. However, I think it's about time that we had a cooling period for when a person retires from office and when he's appointed in another office or service. It is true that the President has the power under Article 80 Clause 3 to nominate a person to the Rajya Sabha who has special knowledge in the fields of literature, science, arts or social service. However, it is very difficult to fathom that the constitution makers had a former Chief Justice in mind. And to conclude on an ironical note, Sri Arun Jaitley himself once said that the judges, they try to make avenues where there are none. Their pre-retirement decisions are influenced by the post-retirement jobs. I think the government should have that in mind.